A very good evening to all of you. On behalf of the Indian Law Institute, the O.P. Jindal Global University and Jindal Global Law School, I would like to extend a warm welcome to all of you to the distinguished public lecture on constitutionalism and the culture of justification, to be delivered by Professor Dr. Moshe Cohen-Elia, President of the College of Law and Business in Israel. I also want to extend a warm welcome to Honorable Mr. Justice Arjun Sikri, Judge Supreme Court of India, and also Chair of the Academic Council of the Indian Law Institute. I'm also thankful to Dr. Manoj Kumar Sinha, the Director of the Indian Law Institute, who unfortunately is not able to be here as he's traveling, but thanking him for his support to this endeavor. I also want to thank Mr. Prusti, Registrar of the Indian Law Institute, and also my colleague, Dr. Sarbani Singh. The topic of today's lecture is obviously a very important issue in the whole concept of constitutionalism and its evolution around the world. The culture of justification is essentially a mechanism on the basis of which the power of the government is made accountable. In some ways, it is for those law students who are present here, you may remember the case of E.P. Royappa, in which Justice Bhagwati talked about the idea of the arbitrariness and how it is central, the idea of non-arbitrariness is central to constitutional adjudication. And the culture of justification, in many ways, the power of the courts to be able to seek justification in the exercise of powers of the government is a very important tool on the basis of which the governments are being made accountable. We in our own country has had an evolution of this power, the role of the courts, including the assertion of those powers of the courts, is an example of how the culture of justification has evolved. Professor Moshe has done extensive work in this area, including a seminal article that he has published in the American Journal of Comparative Law on proportionality and the culture of justification. I invite you to read that article for more information. Without further ado, I now call upon my colleague, Dr. Sarbani Singh, Associate Professor and Executive Director of the Center for Constitutional Studies, to introduce the speaker and also the theme of the lecture. Thank you.
Honorable Mr. Justice Arjun Sikri, Professor Moshe Cohen-Elia, Professor Rajkumar, Founding Vice Chancellor, O.P. Jindal Global University, esteemed colleagues, ladies and gentlemen, it is an honor to welcome you to the distinguished public lecture on constitutionalism and the culture of justification, to be delivered by Professor Cohen-Elia. Hopefully this is the first in a series of public lectures that the Center for Constitutional Studies at Jindal Law School seeks to organize throughout the semester. The center, which is newly constituted, has as one of its aims bringing distinguished scholars such as Professor Moshe Cohen-Elia to address the law school community on new developments in scholarship affecting the Indian Constitution in areas of comparative public law and constitutional theory, on topics such as separation of powers and the role of the courts, judicial review and judicial interpretation, and the scope and interrelationship between constitutionally protected rights. Professor Moshe Cohen-Elia is currently the President of the College of Law and Business in Ramat Gan, Israel, since 2015. He was also the Dean of the Law School from 2010 to 2015, and the founder and editor-in-chief of the CLB Journal of Law and Ethics of Human Rights, which is currently ranked second globally among non-US law journals. He received his LLD from Hebrew University in 2000, completed his postdoctorate at Harvard Law School as a fellow with the Human Rights Program between 2002 to 2003, and was a faculty fellow at the Edmund Safra Center for Ethics at Harvard between 2009 and 2010. The theme of today's lecture by Professor Cohen-Elia is the significant shift in global constitutional law from what constitutional scholars have called a culture of authority to a culture of justification. The latter requires that governments should provide substantive justifications for all their actions in terms of the rationality and reasonableness of every action, and the trade-offs that every such action necessarily involves. Several features of Western constitutional systems that evolved after the Second World War support this culture, such as a broad conception of rights, a broad approach to constitutional interpretation with an emphasis on values and principles rather than on the text, low barriers to substantive review, and removing legal black holes, that is, areas and state actions for which the government needs to provide no justification. Professor Koinelia has also argued that the spread of the proportionality principle in judicial interpretation for determining the validity of state infringement of constitutional rights is essentially a requirement for this culture of justification. To elaborate further on this complex area of law affecting multiple jurisdictions, I would now like to ask Professor Koinelia to address.
Thank you very much, Professor Rajkumar, Honorable Justice of the Supreme Court. Thank you very much for inviting me. And I would like to start with this chart. Okay? What you can see here is a chart that was done by Professor Aaron Barak, who was the president of the Israeli Supreme Court, and he's also a hero of mine. Professor Barak is an expert in the field of constitutional law and has written extensively in the field of proportionality analysis. Look at this chart. What you can see here is how proportionality has turned out to be the reigning doctrine in global constitutional law. As you may well know, proportionality originated in Prussian administrative law of the late 19th century. It then entered German constitutional law just after the Second World War in 1958, and from Germany it entered the European Court of Human Rights decision as well as the decision of the European Court of Justice. From Europe, it affected both Canada in the famous Oak decision of 1986, and again it also entered the domestic decision of the Supreme Court, first in Western Europe and later on in Eastern Europe. And from there, it just spread across the globe. It reached Latin America, it reached Asia, Hong Kong. India, of course, is something unique. I think it developed within India constitutional law without any direct effect from abroad. South Africa, Israel, New Zealand, Great Britain, almost everywhere. There is one exception to the spread of proportionality, which is the United States. In America, it's basically the sole resistant to this trend, although there were several attempts by Justice Breyer and even Justice Kagan to introduce proportionality analysis into American case law, but so far without any success. So actually, this is definitely the most impressive case of a legal transplant, especially in constitutional law. It's the whole world speaking at the same language, this language of proportionality. And I want to move and to present a very simple question in this lecture, the question of why. What makes the doctrine of proportionality such an impressive case of a legal transplant? What makes it fit the needs of so many countries across the globe? And that's the first part of my lecture. So I will present 4 attempts to explain the reason for proportionality yield success. The first attempt was made by Professor Frederick Shallow of the University of Virginia Law School. Shallow argues that proportionality is a standard-based doctrine which allows for flexibility in the development of law and does not bind the court in a specific way. It therefore allows for the doctrine to develop naturally, a quality that is especially important in the first stages of any legal system. So proportionality as a standard-based doctrine allows for flexibility for courts in their early years. However, this early account seems to be contradicted by the fact that there are many cases in which at the early stages there was more formal approach, more categorical approach, while the development was to move toward a more standard-based approach. Israel is one example, and if we were to think about even deeper, we would expect that systems that started with proportionality over time will mature, and they will adapt a more categorical approach if Schauer is correct. But if we look in reality, we would see that both in Germany and in Canada, and actually across the globe, proportionality here is to stay, and there are no signs of some kind of departure from proportionality into a different kind of mechanism, a more categorical one. Okay? So that's the first attempt to explain the early legal development. The second account is an account from what I call conflict management. The argument is that proportionality is effective in managing conflict, especially in divided society, and in lowering the stakes of politics in these societies. It will be interesting to hear, to some extent, in India, proportionality is being used in order to mediate conflict between different societies. Under this account, proportionality reduces big ideological debate into mere factual ones. Let me tell you a story. I studied law at the Hebrew University 30 years ago. When you enter Jerusalem and you want to go to the Hebrew University, you need to go through an ultra-Orthodox Jewish neighborhood. And this neighborhood is very adherent of the Shabbat. And they insist that the main road leading to the university should be closed during Saturday. So we have a conflict here between freedom of religion and freedom of movement of most secular people vis-a-vis the right to protect religious feeling of the ultra-Orthodox people living in this neighborhood. In the Israeli media, this conflict was portrayed as a war over the Jewish identity of Israel, over the character of Jerusalem as the capital of Israel. What Aaron Barak said, he said, well, I don't want to deal with this big issue of ideological matter. I want to look only at the facts. The facts are that for the secular people, it only requires a 2-minute detour to get to their secular neighborhoods. That's it. Once you look only at the fact and you push aside the value issues, then you would get a small, large, commonsensical trade-off. And the whole idea is to look at the fact, and the argument is that proportionality is the mechanism that allows us to look into the fact and to mitigate major ideological debates. Although this sounds very sensible, we all know that facts alone cannot determine what consideration can count as legitimate and what consideration should be rejected at the outset. Take, for example, a 2-minute detour would not be acceptable if it is imposed, for example, on black commuters so that the feeling of white racist residents would not be offended. So I think it's impossible to reduce proportionality or any balancing account to mere factual analysis. There are always values that are involved. If we continue to the third explanation to the success of proportionality. Under the third account, proportionality is successful in creating a common language, a lingua franca of global constitutional law. It is general enough, and yet it captures something essential about constitutional adjudication so that it fits the need of everyone. So, this account also fails to fully explain why proportionality rather than another, more categorical approach is chosen. A common language, after all, can be also a categorical one. For example, in global capitalism, the lex mercatoria is the lingua franca, and it is associated with strong protection of economic right and a certain degree of market certainty. So there is nothing inherent in proportionality that makes it the ideal candidate for being a global lingua franca. So if all these accounts or all these explanations don't work, maybe this account would work. and account from raw judicial power. This explanation is that the success of proportionality may be due to its being an empty concept, which basically allows the court to do whatever they want. It is a book by Ron Herschel, who spoke about juristocracy, basically referring to a phenomenon in which more and more courts across the globe are grabbing power, by the way, and also by applying proportionality analysis. While I do not want to deny that judicial power may account to some of the spread of proportionality, it is important to remember that the power of the court is primarily a veto power. Thus, the raw judicial power account seems to miss a very important point, that the application of proportionality is generally accepted by the public as a legitimate exercise of judicial authority. This is the main issue. So we saw 4 explanations, and while I do not want to totally dismiss all this explanation, there are certainly difficulties in each one of them, and taken as a whole, they do not provide the full picture. The stress, the more technical, more instrumental aspect of proportionality, and instead I want to present here a more intrinsic explanation to the spread of proportionality. And in what I'm going to present now is a joint project of my colleague Ido Porat and I, which we eventually assembled into a book called Proportionality and the Constitutional Culture. Ido and I argued that these accounts miss the essence of proportionality, which is basically a requirement for justification. When we apply proportionality, we basically ask the court to justify, or ask the government to justify their action on substantive ground. So the global trend toward proportionality is a global move toward justification. It responds to a very basic intuition in liberal democracy. We want the government to justify everything it does. The government is accountable for us, the people. And essentially, in order to understand why justification is so strong, we need to understand the culture of justification that supports this movement, the culture of justification. Now let's pause for a second and look at this picture, which is inspiring, okay? It brings us back to the transformation of South Africa from an apartheid state into a democratic one. The first person to coin the term a culture of justification was a South African scholar called Etienne Mounique. Etienne Mounique was a public law scholar who fought against the apartheid, and unfortunately he passed away under tragic circumstances before having the chance of seeing the full end of the apartheid regime. Mounique presented the culture of justification as an ideal for the new South African constitution and contrasted it with the culture of authority that characterized the apartheid regime. Look at this beautiful citation by Mounique. I think it is very powerful and captured the whole notion of a culture of justification. If the new constitution is a bridge away from a culture of authority, it is clear what it must be a bridge to. It must lead to a culture of justification, a culture in which every exercise of power is expected to be justified, in which the leadership given by government rests on the cogency of the case offered in defense of its decision, not the fear inspired by force of its command. The new order must be a community built on persuasion, not coercion. While for Mounique, the notion is to contrast democracy versus authoritarianism, we took the notion of a culture of justification into a different twist. So we are basically looking at different liberal democracy and contrasting two models. The model of a culture of justification and the model of a culture of authority, which we associate with some of the characteristics of American constitutional. So I want to move on and present 5 main differences between American constitutional law, Europe, and basically the rest of the world, the features of the culture of justification. What does it mean? First, in a culture of authority, there is a very strict division of labor. The existence of distinct institutions for distinct sphere of life, each best equipped to act within its sphere and accountable for its action within its bound. And as far as judicial review is concerned, this means that the task of the court is to police that the border of the division of labor are kept and to make sure that each institution is operating within its bounds of authority. That's in a culture of authority in the US. In a culture of justification, to use Murnick's word, every exercise of power is in need of justification, since justification rather than authority is the main source of legitimacy. What does it mean? This means that essentially in a culture of justification, there are hardly any procedural barriers to approach the Supreme Court. Take Israel, for example, almost no justiciability, no requirement for standing, and what Aaron Barak has famously said is that law is everywhere. And where law does not apply, there are black holes which might use to an abuse of power. And this automatically has a huge impact on the size of the docket. Take the US, for example. For a population of 330 million people, you would have 70 cases a year heard by the American Supreme Court. While for Israel, for a population of only 8 million people, you would have more than 10,000 cases heard by the Supreme Court every year. How many cases here? Okay. But the population is much larger. Israel is a town in India. Okay. So that's a point about the source and the division of labor. Okay. The second difference, here, it's okay. The second difference relates to the notion of rights in these systems. Okay? And there is, of course, a connection from the division of labor to the notion of rights. In a culture of authority, right can be viewed as marking the boundaries of the governmental sphere of action, as imposing a restriction on governmental action. Take the right to free speech. The right to free speech can arguably be conceived as basically saying to the government, keep out from the market of ideas. It's beyond your boundaries. That's the notion of free speech within the system of a culture of authority. This may be called exclusionary reason approach that is very popular by many American legal scholars such as John R. Ely. In a culture of justification, on the other hand, rights are viewed as values, as substantive good that reflect aspiration to progress and rationality. Rights, to use a more philosophical terminology, are viewed in perfectionist terms, as value that needs to be optimized. This is the account of rights as requirement for optimization, as values. Robert Alexi from Germany. The effect of this conception of rights was an expansion of the scope of the right. In Germany, this expansion was radical. the German Constitutional Court went as far as to say that even trivial pursuits such as smoking marijuana or getting a permission to import a specific breed of a dog or even riding horses in the park, these are fundamental rights that need to be protected under the German constitutional law. So essentially, in Germany and in a culture of justification, everything is a right. Now let's move on to the role of the text in a culture of justification and in a culture of authority. In a culture of authority, the court is the institution that must base its legitimacy on authority rather than on justification. Therefore, the constitutional text is of utmost importance. It is the source of legitimacy. This is why in America we see persistence of originalism, something that hardly occurs outside of the US. In a culture of justification, the judicial role is to demand for justification. I don't need a text for that. Essentially, if I was asked to draft a constitution that is built on the notion of a culture of justification, there would be one sentence. The government has to justify everything it does in terms of proportionality. I don't need anything beyond that. In fact, sometimes for a culture of justification, the text is an obstacle. Look, for example, in the limitation clauses that appear in the European Court of Human Rights or in other European constitutional texts. They try to devise different mechanisms restricting different kind of rights. What the courts actually did, it looked at the whole as one thing and actually created one proportionality analysis for the whole constitutional text. So for a culture of justification, text is a limitation, it's not a requirement. This leads me to the fourth feature of a culture of justification. The culture of authority is more skeptical of human reason than the culture of justification and places a greater emphasis on the need to finality. One manifestation of this aspect of culture of authority is the well-known statement by Justice Jackson that said, "We are not final because we are infallible, we are infallible because we are final." This saying captures skepticism with regard to human infallibility and a sense of humility with regard to judicial capability. In a culture of justification, this is something that just stands in the opposite of this idea. By emphasizing the need to justify every decision in terms of its reasonableness, it expresses optimism with regard to human capability and human and judicial capability to get things right. Some people would say that this might be termed even some kind of conceit, epistemological conceit. And the last point, which leads me to the end of my presentation, relates to different conception of democracy between a culture of authority and a culture of justification. A culture of authority is more related to the pluralistic notion of democracy, while a culture of justification is more related to a deliberative notion of democracy. Under the pluralistic account, democracy is an arena in which different interest groups are struggling for their share on the sources and interest and value and the allocation of these resources. This struggle is resulted in a compromise, not an agreement. Compromise arrangement that actually reflect the relative share of the power of each interest group. What motivates group and individual is not an appeal to rationality, but it's often justified by an appeal to power. By contrast, under a theory of deliberative democracy, law gain legitimacy only if they are the outcome of a deliberative process, a result of public discourse in which public attempt is made to justify arrangement in terms of reason. A proper democratic process is based not on power, but on attempt at arriving at an agreement, rather than an attempt to arrive at a compromise. So, if we put everything together and we're trying to figure out something that might be very technical, what does it matter if it's called balancing, proportionality, reasonableness? There is something very deep about the spread of proportionality, which, in my opinion, reflects a shift in global constitutional law from a culture of authority to a culture of justification, and essentially proportionality is the culture of justification. It's the mechanism, the ultimate mechanism. David Beatty called it the ultimate rule of law. The ultimate mechanism that requires the government to justify any of their actions. Thank you very much.
It is an honor to be able to introduce the Honorable Mr. Justice Arjun Sikri, who will be delivering the presidential address. With a distinguished academic record and a career of eminence as senior counsel specializing in constitutional cases, labor and service matters and arbitration law, and part-time academic at the Campus Law Center of Delhi University, Mr. Justice Sikri was appointed as judge of the Delhi High Court in 1999. He became the acting Chief Justice of Delhi High Court in 2011 and the Chief Justice of the Punjab and Haryana High Court from 2012. He was subsequently elevated to the Supreme Court in 2013. He has been conferred a Doctorate of Laws, honoris causa by Ram Manohar Lohia National Law University in 2013. He holds positions as a member of the General Body and Academic Council of the National Judicial Academy, member executive of the International Law Association, and member of the Directorate of Legal Studies and Law Reforms Committee of the Bar Council of India, amongst others.
Thank you, Sabani. Good evening to all of you, dear friends sitting on the dais, Mr. Moshe, Mr. Rajkumar, Mr. K, and dear students. See, in this very distinguished lecture given by Professor Moshe Cohen, you have been introduced to the doctrine of proportionality and the justification behind it. I don't know how many of you know whether doctrine of proportionality has been followed or applied by Indian Supreme Court or not. There are various judgments which I'll refer to in brief, where this doctrine has been applied. But making the things easier for you to understand in Indian context, let me start, because the topic is constitutionalism and the culture of justification. Now, as all of you know, that Constitution of India is the highest piece of legislation. We don't even call it legislation because it was drafted by the Constituent Assembly and given to us by ourselves. That is why we say, we the people of India. That is the preamble, it says, have enacted this constitution. So this is the instrument given by, which is very, very important in understanding what I am going to say. That this document of governance of this country, which is described as Grundnorm also by the jurists, is the document where people of this country have given it to themselves. And that is why we treat this document as not a document which is say static in the history, that on 26 January 1950 and those members of the Constituent Assembly who drafted the Constitution, they gave it to us. It is not even the nationals or the citizens who were there in 1950 were walking or were living creatures in this country as on 26 January 1950 they gave it to themselves. Once we call we the people, it is a document in continuum. So even today, this population 1.28 billion people of this country can say that it is the Constitution which is given by us to this country. And that is why we have a right to be governed by this Constitution alone. Why I say so? This Constitution, as I said, is the document of governance. And as you know, on the one hand, there are two very important chapters. One on fundamental rights, we call it human rights in human rights language, and one is directive principles of state policy, as to what the state is supposed to achieve, the executive in the manner in which they should function. And that's a mission, that is a dream which is reflected in the Constitution, which any government is supposed to give it to the people. And of course, fundamental rights are those rights which are guaranteed to every citizen of this country. And there are some rights which are not limited only to the citizens, but apply to even non-citizens also. That is one part. And the another significant part is that the three wings of the state, legislature, judiciary and executive, their powers are defined in the Constitution. We have, since it's a federal constitution, we have union government, union legislature, and we have state legislatures. So even union legislature, what are the topics on which it is supposed to legislate? Those are prescribed in the 7th schedule, list 1. Likewise, state legislatures, the topics are assigned in list 2. And of course, list 3 is the concurrent list where both union as well as state has the concurrent right over it. And in the same manner, the power of executive is defined, and there is a chapter on judiciary also. How the judiciary is supposed to act is defined. And it gives us the doctrine of separation of powers. That each of the wings, each of the limbs of the government, of the state, has to act within its sphere. This is very, very important. And whether they are acting within their fields or not, or they have overstepped. And if that happens, the final arbiter is the judiciary, which is given the power of judicial review. And in Indian context, like in America, Canada, Australia, etc., the power of judicial review doesn't only relates to judicially reviewing the administrative function or the executive function, but judicial review can be exercised in respect of legislative function as well. So therefore, if any law is made by the parliament or the state legislature, and this law is contrary to any provision of the Constitution, or it is not within the power of that legislature, if it is a state legislature, it has enacted a law which is not within its powers, which are, as I said, is enshrined in list 2, or if it is the parliamentary legislation and it is beyond the power prescribed in list 1, then that law can be declared unconstitutional. And it gives us another very, very important facet of our constitution, which is treated as basic feature of the constitution, is that rule of law which permeates in this country. That is, everybody is subject to rule of law and has to act within the bounds of rule of law. And that is why it is said that the very famous saying, howsoever high you may be, law is higher than you. And in this context, now I deal with the doctrine of proportionality. When the power of judicial review is there, and the courts have right to declare any law as ultra vires the constitution, or ultra vires the powers of the parliament, or contrary to or infringing any of the provisions of the constitution, either fundamental rights or any other provisions, it can be declared unconstitutional. Now this judicial review, when we interpret the constitution, while whether it is contrary to Article 14 or not, contrary to Article 19, 21, etc., any piece of legislation which comes, then if the challenge is laid on the ground that it infringes equality clause enshrined in Article 14, court has to see whether this in fact is violative of Article 14. So in the process, Article 14 will have to be interpreted in that context. Likewise, if the challenge is laid on the ground, it is violative of Article 21, right to freedom or liberty, Article 21 would be interpreted. Likewise, Article 19, or as one example was given by Professor Moshe in respect of religion in the country, here also we have religion is a part of fundamental rights. Now, while interpreting the constitution, there are many tools which are adopted by the courts, and we know, as one I have said, that it should not be ultra vires, etc. And as far as rights are concerned, or fundamental rights are concerned, there is one doctrine of originalism which Professor Moshe also described, which is confined only, and that debate is only in America. It has not been applied elsewhere. And this doctrine says that, look, whatever the original document when it was enacted, what was the intention of the constitution makers at that time, and it should be seen only in that spirit. But as this doctrine of originalism has not been accepted in other countries, including in India, where we say that it is a dynamic constitution, and depending upon what are the circumstances and why it has, because it's a constitution which is given to generations to follow, for all generations to follow, therefore it cannot be static. And what is the meaning, depending upon the times which are there today, depending upon the cultural values, etc., it would be applied in that sense. We have the tools of common law tools, which are common law principles on the basis of which many times many articles, etc., are interpreted. But when it comes to any law which is made or any action which is taken, and as I said, rule of law is important in that sense. So it is also examined in the context of whether it is violative of any rule of law. Now, the new concept which has come in this context is the rule of proportionality, which can be one of the tools. If you see Article 19 of the Constitution, it gives us various freedoms. It talks of freedoms, 7 originally, 1 right to property is no more a fundamental rights, although it still remains a constitutional right under Article 300 capital A. But then these freedoms are not absolute. The legislature is given a right to impose reasonable restrictions, and those restrictions can be in public interest, in the interest of security of the nation, etc., which are in sub-article 2 of Article 19. So in a given case, when case comes and a person says that my fundamental right guaranteed under Article 19 is violated, say it is 19(1)(a), freedom of speech, or freedom of movement, or freedom of trade or profession, freedom to form union or association is affected, and the first question would be, it is a 3-stage judicial review which is to be undertaken. The first question would be whether it is so. If it is not, matter is finished at that stage itself. If it is so, then the second stage would come, that whether the restriction which is imposed, which may be infringing any of these rights, whether it is reasonable. Then the court will go into that question of reasonableness. And if it is found to be reasonable, then law would still be upheld. And if it is not found to be reasonable, it is unreasonable, then the third stage is that what should be done. There are various, it can be read down, it can be, the court can say that this part is offending, this can be remedied in such and such way, or the entire act or the law can be declared unconstitutional. But coming to the second aspect of it, when we talk of balancing, here the doctrine of proportionality comes. When we talk of reasonableness, and as very rightly pointed out, and this is a really nice thesis which that German scholar, I've forgotten the name of that professor, who said from authority to justification. Yeah, that's sorry, South African, yeah. So here, this doctrine of proportionality is nothing but balancing in one sense, and in second sense, checking the arbitrary power of the state. And it has thrown open very interesting issues in Indian context. Of course, it was in S.R. Bommai case, Indian Supreme Court had initially applied way back in 1994. But then this doctrine has been applied in various subsequent cases. I had the occasion to deal with this in a judgment given in 2016. It is that NEET case, if you remember, second inning of NEET. Of course, that NEET main case is still pending, only in review. That earlier judgment has been set aside, but the case is still pending. But it is, the name of the case is Modern Dental College and Research Center versus State of MP. Now here, in the context of Article 19 and explaining, because that was a case of where they said that it's our right to business, or the education is not business but avocation or calling, etc. And therefore sub-article 6 of Article 19, which says again of reasonable restrictions, and in that context it was said, I won't read from that judgment, if you in detail, there's no point at this stage, but if you read from para 59 to 70 of that judgment, and it is under the caption Doctrine of Proportionality Explained and Applied. And there, Professor Moshe, I have extensively quoted from Justice Bharat's book on proportionality. And what I have said at the end, that yes, it amounts to balancing these two, and that has to be done. So the aspect which is highlighted by Professor Moshe, that from authority to justification, this is in the context should be, and if that becomes the focus of the judge or the court while deciding on whether a particular action is reasonable or it is comes under that exception or not, it becomes very relevant. Because today we know, and another judgment, if I cite today right to privacy, or recent judgment, and even in triple talaq judgment, Justice Rohinton Nariman has discussed in detail. I'll come to that in 2 minutes. And another case in which it is being argued today as well, on which I can't comment in detail because that is one case which is being heard and on Aadhaar, and I am a part of the bench, Constitution bench, which is hearing this matter. So there also doctrine of proportionality is stretched or stressed also. But yes, article as well as Article 19 is concerned, subclause 2 to 6 are there to talk about reasonable restrictions, etc. And therefore, the concept of balancing you can always apply, and doctrine of proportionality in that sense is always applicable, where we can call upon the government or the state or the legislature to justify how it is reasonable restriction. So that kind of justification doctrine comes into picture, and that is why I said that this would be a very interesting facet or an interesting idea that Indian judiciary also starts applying the doctrine of this justification in applying the rule of proportionality. But another aspect is, which is very interesting aspect, is Article 14. Now Article 14, as Professor Rajkumar also mentioned about that judgment in Europa case, that any action which is arbitrary is illegal or unconstitutional. Arbitrariness, non-arbitrariness is to be read in Article 14 also. But very interesting thing is that these are the cases in administrative law. The question is, if a particular legislation is challenged on the ground that it is violative of Article 14 of the Constitution, and you read the doctrine of proportionality in that, if it is therefore what I am saying is, any law passed by the Parliament, a statute, can it be struck down on the ground that it is unreasonable? It's a debate which is on, a very interesting debate, and here the doctrine of proportionality has been applied by Indian courts even in adjudging a particular case on the touchstone of Article 14 of the Constitution. And that is what Justice Rohinton did in triple talaq matter. And if you see here again, for paucity of time, I will not be reading from that discourse in detail, but it almost starts from paras 62, 63 and goes up to para 90 or so. And very interesting thing, ultimately Justice Nariman has said, because there were two lines of cases. One has our Professor Lokendra Malik was just nodding his head, saying in no, this is one view in so many cases which has been decided. But then Justice Nariman said there that no, Menka Gandhi and even Bommai etc. had decided, and even Batra's case etc., that unreasonableness can be one of the grounds even to strike down a legislation. Now it throws open a very interesting issue. Parliament is supreme in the sense that if it is within the power of legislature to enact a law, then it has right to enact that law. If that law is not violative of any provisions of the Constitution, then the courts cannot strike down. Now, whether a particular law meets the test of reasonableness to what extent the courts would go. Can a court say that, look, my conscience states that this kind of law should not have been passed by the parliament? Their judgments galore, court can't go into the wisdom of the parliament. If law is made, then on the other hand, other extreme, if you see the way Dicey pronounced or explained the concept of rule of law. He said rule of law would not only mean that there is a law and therefore that law is to be followed, it is rule of law. Then even a dictator in a particular country where it is dictatorship, they can say, yes, if somebody, there can be a law made, valid law by the parliament or by the dictator, that if somebody commits theft, his hands will be chopped off. Or for a small, say, case of theft, is the capital punishment, he would be hanged. The question is whether it would be a reasonable law, whether the court can go into, if Indian Parliament enacts such a law, whether the court can go into it. Here the answer in that context would be yes. And here the theory of justification and proportionality is applied. That the deterrent effect or the punishment which is prescribed in the example I have given, it is so shockingly disproportionate. It doesn't meet the test of proportionality. So therefore, not that in the, whims and fancy of a particular judge, it is disproportionate, it could be done, but a very, very high standard test, that when it shocks the conscience of the nation, it shocks the conscience of the people, that such a law, then the courts can calm down. And that is what is upholding the rule of law, that is what is upholding the Constitution. So therefore, in that context, this theory of providing justification, the culture of justification, is in any liberal democracy, is a very, very important tool which may deter the executive or the legislature from going overboard. And in that context, I really commend Professor Moshe to give such a beautiful lecture. Thank you very much.
We can take a little bit of a few questions if there are any. Taking upon what Justice Sikri said, I wanted to quickly refer to that. This is the idea of how societies can actually be governed by the law, but if that law does not have the basic framework of proportionality, they will of course fall short of what we're trying to achieve. I want to draw your attention to March 23rd, 1933, Adolf Hitler. There was a law passed in the German parliament, and that law was very, very clear, and through that law resulted in the dictatorship that was obviously enforced. And it's very useful to read the provisions of that law. The decisive sentence was that in addition to procedures prescribed by the Constitution, laws of the Reich may also be enacted by the government of the Reich, unquote. That second clause had drastic implications. With no need for parliamentary approval, Hitler's government could enact laws and enter into agreements or alliances with other countries. Practically speaking, German parliament was being asked to render itself impotent. The point which we are talking about is that we need to be conscious of this. Before I invite a few questions, I just wanted to react to Professor Moshe's one aspect of it, which Justice Sikri mentioned, that while the culture of justification will enable governments to justify their actions, to what extent those justifications ought to be assessed in the prism of reasonableness or fairness or justice. The reason I ask this question is that the Indian evolution of jurisprudence in this area, I believe, had actually been even more far-sighted and had actually become conscious of the fact that it's entirely possible for governments to give all kinds of justifications for their various powers. And it becomes even more difficult on the part of the courts, as Justice Sikri mentioned, to actually decide what are the circumstances under which this justification which the government is giving is actually fair and just and reasonable. And I dare say it becomes indeed a subjective assessment on the part of the courts. And the courts have not only the constitution, but also it is deeply embedded in the constitutional culture of our country that the courts have been given this power to determine as to the culture of the justification provided by the government is indeed constitutionally permissible. And that's a very important distinction that Indian jurisprudence contributes to the larger context of the culture of justification. I'll leave it here. I'll leave you to respond it together. You can kindly note down. Any questions, comments? We will have a few questions to take. Please.
I would just like to ask, I was reading about the banning of films in Israel. So when you're talking about this culture of justification, why is there a culture of banning films in Israel? If I go specifically, then maybe supposing if there's a film opposing the culture of Jews, will it be allowed? Thank you.
Let's take comments. Any more questions, please?
Thank you for referring this arbitrariness or unreasonability issue, especially Justice Sikri, sir. What I find regarding this unreasonableness and arbitrariness, while reading Rajbala or Sharabano, I found that none of them address each other. For example, Rajbala does not take note of Maneka Gandhi, and then it raises various questions that how could you decide reasonableness when it is the wisdom of the parliament. On the other hand, while Justice Nariman took note of Rajbala, he referred it, declared it is not good in law, but of course he has given very good justification of how arbitrariness doctrine is involved in Indian constitutional jurisprudence. He did not answer the query that is actually raised, that was the rationale of Rajbala by Justice Chalameswar, that to what extent that you raised, to what extent you are going to decide the reasonableness once you go inside what is reasonable, what is not reasonable. I think that this issue should have been really addressed by this Sharabano judgment, or maybe sometime when occasion comes, this issue needs to be addressed properly. Thank you very much.
Professor Mose, first of all, I'm Dr. Loken Malik. I'm a practicing advocate in the Supreme Court. First of all, I would like to congratulate you for delivering a very interesting and thought-provoking lecture. Do you have any provision like public interest litigation in your constitutional system, where there are many cases where our apex court has made laws, which is called judgment, to fill up the vacuum or to give relief to the people who are not able to knock the doors of the court.
Last question.
Okay, thank you very much for a very insightful question. First, Raj, regarding your question as to the connection between proportionality and reasonableness, there is something I think more attractive in proportionality if we compare it to reasonableness. First, when we think of reasonableness, usually we give it with a wide range of deference. Okay, so at least for many British people, this is associated with non-intervention, while proportionality is associated with more activist work. But I think the most important point is that proportionality is is cut into 3 stages, which are very analytical and very helpful to make a better decision. First, we need a rational basis between the means and the end. Then we should apply the least restrictive mean, and then we move on to the balance stage, where there is also a probability analysis. I think David Beatty, which described proportionality as the ultimate rule of law, there is something to it, because this is basically the best way to get into the best decision. This is the method for optimization. Therefore, I think it's more useful for the courts to make a better analytical decision regarding the merit of each case. Regarding your question, in Israel, the extent of free speech is very strong, okay? There are no banning on films. Let me explain. There is a provision in the law that allows the council, a specific council, to restrict or not allow some films if it harms the public interest. But the court interpreted so narrowly, especially around Barak, that currently I don't remember a case in the last 40 years in which a banning of a film was upheld. I remember 30 years ago when I was practicing law at the Supreme Court Division, there was a case in which there was an attempt to ban a movie called Happy Holocaust, which sounds very sensational in terms of Israeli, but even in this case, the court forced the government to uphold this. It is true that the government does not want to give money to this kind of film, okay, and that makes sense, but there is no censorship in this respect. With regard to your question, Israel is a very vibrant civil society with many NGOs. For myself, I was practicing law for the Association for Civil Rights. I litigated cases in the Supreme Court, presenting the vulnerable community, promoting anti-discrimination law in public accommodation. As my law school at the College of Law and Business, it is extremely activist. Its legal clinic are bringing cases to the Supreme Court and striking down law. For example, striking down law allowing for the privatization of prisons. So there is quite an activity in the civil society in Israel.
Just answering your question,
Yeah.
You are right in pointing out what you have pointed out. Therefore, if you remember, I said that this is still the court struggling. I use that expression and because I'm presiding over the lecture which is given by Professor Moshe, so we were confining to that. So I didn't want to enter into that debate in detail. But one thing is there, and which is, I said that shockingly disproportionate, etc. I tried to give that answer in a ready or simple answer. But otherwise, Justice Nariman has noted in some of the judgments where the test of manifest arbitrariness. So therefore, it should be so manifest that arbitrariness that nobody is ready to accept. So, which I said like shockingly disproportionate and proportionality test. So in that context only I said yes, ultimately this is one area which is still a grey area and it will have to be resolved whenever I think chance comes before the Supreme Court, a larger bench, 5 or 7 judge bench may ultimately resolve this. But it is not difficult to reconcile the two kinds of judgments by applying the test of shockingly disproportionate or manifest arbitrariness. Yes, how it has to be applied in the given facts of a particular case, keeping in view that otherwise the wisdom of Parliament in enacting a particular law cannot be questioned by the court. And courts, these are the policy matters, these are the, whether it is legislative policy or administrative policy, courts cannot interfere with this unless it is too arbitrary or manifest arbitrariness which is shown. So test is there, how it is to be applied in given circumstance would be a test for the Supreme Court. Yes.
It's a very interesting topic today, sir. To coming to the end, I'm very much thankful to Honorable Mr. Justice Sikri sir for providing some time from his very busy schedule for this topic, which is enriching for our students as well as for the faculties. I'm thankful to you, sir, for being present here. I'm thankful to Professor Moses for being here and in India and providing his knowledge, sharing his knowledge with our Indian counterpart. Thank you very much for this your sharing of the knowledge. I'm thankful to the C. Raskar sir. He is always a source of inspiration for both General Law School as well as our Indian Law Institute. We are doing a lot of series of lectures jointly. Thank you, sir. And thank you, ma'am, for developing this year. Lastly, to all the audience, most of them are students, sir.